for our last plenary of the morning, beginning to implement the vision. For the rest of the conference, we have the plenary on legal education, community lawyering, and the courtroom. And we have, as presenters, Rhonda McGee, who is a close friend, a law professor at the University of San Francisco, a leader of the contemplative law movement, and a great writer on the need for a redemptive approach to law, a reinterpretation of the Equal Protection Clause that draws on the upward movement of the abolitionists and others to create a post-racial society grounded in human dignity. We have Lenny Noisette, who I've only met on the phones. Rhonda and I have been friends for years. Lenny I've only met on the phone, but really very much like talking to you, and a little bit of preparation for this panel. You seem like a really interesting and open person, and with a much great experience. Lenny's the director of the Justice Fund for the U.S. programs at the Open Society Foundations, leading efforts to reduce mass incarceration, eliminate harsh punishments, and promote system accountability. And Lenny was the longtime executive director of the famous Neighborhood Defender Service of Harlem, which I heard about as an embodiment of community lawyering 15 years ago. I don't know, it was a long time ago that I heard of it, heard rumor of it, and I'm very pleased that we have you here. And Doug Amar, who's the executive director of the Georgia Justice Project, who has out of his West Virginia origins and coal mining heritage and preacherly past influences and education, created a remarkable law practice that fuses the spiritual impulse and knowledge of the other with a powerful representation and really lifelong devotion to clients. So, three wonderful people. Go ahead.
Welcome back, everybody, back to our circle, this kind of learning community that we're creating here together, spontaneously and ritually. I am in a state, I can feel a certain anxiety in my body about what I'm about to talk about. So bear with me, and I'm actually going to consciously invite your support, right, as I kind of try to sort of give voice to what I think most needs to be said in this moment. And even as I, just after having this wonderful conversation with this group of lively, thoughtful beings here, was reminded of the depth of the challenges that we're talking about. Like really, not only from this conversation, but building on everything that's gone before, the panels that have gone before, the presentations by Peter and Annette, which, again, I love listening to Peter describe and diagnose sort of why we're here in a sense, like what it is that we're kind of up against. It's deep, it's real, it's pervasive, it kind of impacts us all and has impacted us all in so many deep ways, and it's impacting the world in so many deep ways that the challenge of talking about how legal education, which is my piece up here, how legal education is beginning to try to implement a vision of spiritual progressive law, right, which embodies these values we've been talking about. This to me is a very daunting challenge in the moment. So I kind of already appreciate the kind of affirming nods that I got when I said I need your support to kind of get through this. So I passed out, or asked to have these cards passed out because one of the things I want to invite from you as you sit with us and as you engage with us, right? We do want this to be kind of an interactive experience, not only this part where we're talking a little bit at you, but really I'm hoping that you are going to stay present with me and with this project as we go, and to support you in that. Again, this is a contemplative pedagogy piece, example of it right here. Passing out these cards and asking you not only to kind of jot down kind of questions that might arise, which is kind of standard way we might invite you to kind of stay engaged. Do that. But if you would also allow kind of random thoughts that keep coming up for you as you're sitting and listening to us, jot down on something that you can use to remind yourself what that thought was that kept coming up. Again, this is just for your benefit. And maybe we'll ask to collect them, but nothing, you need not identify yourself in any way on this. So questions that arise, any random thoughts that could occur or seem important as you're listening to any of us, emotions, right? If you hear something up here that touches you in some way, if you would jot that down, I'd love for us to keep alive the fully embodied nature of what it means to actually engage with these really important questions in real time with real bodies around us together. And so other embodied sensations, right? If all of a sudden as you're doing this, you find yourself getting clumsy, or you find yourself, getting sort of tense because something about this is, you feel it in your body, you're not sure how you're gonna contribute to this conversation. Note that kind of stuff down. So in those ways, I want to invite you really to be present to yourselves as you kind of play the role of the audience member, and we kind of do what we do up here. And then afterwards, we hopefully definitely have some time to hear some of your reflections on any of the mentions you're willing to share. We'd love to kind of invite that in. Okay, so how can legal education do its part, right, to help us advance a spiritual progressive vision of the law? How might what we are teaching students in legal in law schools and what we're offering in the way of continuing legal education and continuing judicial education? So I'm going to put those two on the table as well, because I'll talk primarily about law school and what's happening there. But when I think about legal education, what I think is important for us to think about is, I think inherent in this vision is this idea that we're lifelong learners, and that if we're going to be effective advocates, leaders, lawyers, all the things that this body of professional knowledge and training opens us up to in the world, the different roles we get invited to play in the world as a result of telling people anywhere we've had any kind of legal education behind us, right? If we're going to play the kinds of roles that we're asked to play in this alienated world in ways that as much as possible embody these things that we think are really important to bring forth, how is it that what we're doing in law schools might support us in doing that better? I think Peter's comments in particular helped us begin to see how what's happening in law school or has happened traditionally sets us up for a challenge in terms of bringing this vision forward. So traditional legal education, you all are products of it. Maybe not everybody in the room went to law school. Is anybody here who did not go to law school in the room? Okay, so we do have a couple people with non-law. Where are you guys? What's your background? Medicine and English. Okay, so we do have a couple, and we have folks who have been in law school some time ago. Some people are in law school right now. Some recent graduates. So, and those of us who didn't go to law school have experience with working with lawyers who know people who are. So the idea is that traditional legal education is quite a formidable training ground that has for really more than a century been deeply committed to the kind of 18th century model of what it means to be a human being and the rights model that Peter described. So there is a kind of a deep commitment across the country to a traditional core curriculum in legal education comprised of a set of knowledge or body of knowledge that law students need to be exposed to, a set of skills, and more implicit than explicit, but sometimes explicit, a set of values that are supposed to be a part of what a law student must be exposed to be confident in the world, right? So knowledge, skills, and values tied to an 18th century paradigm of what it means to be a human being in society. So I've been teaching in One Step Law School, University of San Francisco, for more than 16 years. After past 15, you just start losing the grip on the exact number of years. It's been a long time. Been teaching at USF this year. This particular fall, I'm teaching at Berkeley, UC California, a Berkeley School of Law. And at USF, I've taught tort law. I practiced before going into teaching in the insurance law field, so I taught for a while insurance law classes. Immigration law I took up because I was actually teaching race law, and all my students in the race law classes tended to be either themselves recent immigrants or for families that were recently immigrated. And I wanted to really understand the intersection between race and immigration. And so somehow got myself into teaching immigration law for a while. So I've taught these kind of basic and core doctrinal classes, with tort law, personal injury law being my bread and butter for all of those years, and then these other classes coming in. And at a certain point, actually very early on, I realized, wow, there is a lot that we are not teaching as well as we might here. In fact, I think my sense that legal education needed to change dates back to when I was a law student, and really came into law having grown up in the South, born in the desegregating South, you might say. I mean, some would wonder if we've ever quite desegregated, but we certainly, in the late 60s, early 70s, were more committed, as Peter suggested with regard to the movement around affirmative action, we were more committed during the era in which I was born to changing the world. And we realized that the law had a role in actually moving the world forward. And so I grew up in that time, in that place, but in a family that was quite resource strapped. We did not have a lot of money. There was not a lot of education in the generations prior to my own, and even amongst my own siblings. So there was a lot of the kind of physical, material deprivation that is a predictable consequence of centuries of oppression and segregation and all of that. There was abuse also in the home, and alcoholism, again, the kind of social, psychological, spiritual consequences of being a member of a subordinated class and having that really be a felt experience in our home, right? So I grew up in having come through that, and then by kind of the miracle of the social movement that was integration, affirmative action, efforts to actually identify people in these under-resourced communities who could succeed and actually support them, right? Support folks like me to actually have an opportunity, a set of opportunities that my parents, no one else had ever had. My grandmother and grandparents were sharecropper, day workers, effectively very similar to the Latino workers who come to our country right now. They were working for, when I was a kid, for many of the tobacco companies in North Carolina. My grandfather, standing on a corner looking for day work for tobacco companies. Grandmother cleaning homes for families. That was the life I was born into, and had my lineage had been kind of targeted for that. Okay? And something profound happened in the 60s that ended up with me being here instead of there. So I grew up with a felt sense that the law and society could change for the better, and a commitment to somehow participating in that in any way that I could. So fast forward, went to school at University of Virginia and studied sociology, was on a PhD track, looking at how people resolve conflict better, more effectively, from a sociological lens, and ended up going to law school because of that interest. So I say all that to say I got to law school having some positionality. I think all of us does. That's actually, I think, the beauty and the gift of diversity and difference. We actually do come from different places in the world. Just our little small group conversation just now just gave us an example of that, right? We think we're all going to think the same way. No, we don't. Even when we sort of look alike. Amplify that by we sort of don't look alike and we sort of have very different experiences in the world before. And yet we can learn so much from each other by talking to each other through the shared reflections on our different positions in the world. So I come to law school from a sociology background, which is bad enough, but also being an African American from a poor family, et cetera, and going to the University of Virginia Law School, which was a very, and is still, a very conservative law school, where everything that Peter just talked about was sort of the day-to-day experience. And so I was drawn to finding folks who could help me figure out a way to stay in it, because I guess that's what I'm sitting with right now. I feel the challenge of working in this oppositional space, this paradoxical space, this space of we have to teach students certain knowledge, skills, and values consistent with the way the world is right now, or else they will drum us out. The students will drum me out of the classroom if I stand up and only, give them the loving kindness meditation in my torch class. I would get away with maybe 15 minutes of that before they're all, So literally, there is a huge curriculum that I must cover, right? And then but at the same time, my own contemplative awareness, my own deep commitment to this pie-slat vision constantly pushes me to try to bring as much as I can forward that counteracts against that the traditional teachings of the poor forces, that we're isolated, this libertarian view that, if somebody's in trouble, you actually have no legal obligation to help them, right? That whole duty to rescue thing. In our small group, one of the comments that came out was that after we're talking a little bit about how some of us teach law school and how that's impacted us all, reflecting on these comments from Peter, one of the comments that came out was a story was shared about one of our members having taken a post-bar trip and finding herself getting lost in another country. And the felt sense that arose was, and again, the person who shared the story indicated that her sense was this was a direct legacy of law school. That, okay, I'm lost, I don't know, I need some help, but nobody here is obligated to help me at all. Nobody's here, I'm on my own, right? More or less, I am on my own. And that kind of, again, like hearing it from the words of somebody who's graduated law school in the last decade or so, and that vivid sense still in the body, that when we come away from law school is with like this braced sense that we're up against it by ourselves in these monad circles, as Peter talks about. And so, and then here I am teaching these classes in which I know that I am part of that I am sort of the man in that with regard to that, right? I am the person teaching the Paul's graph case. I am the person teaching the elements of negligence. I am the person saying, you need to understand this sort of no duty to rescue rule, except when there are these exceptions and special relationships and so on and so forth, and promises and all of that. I'm teaching that on the one hand, and yet I'm committed to doing something to try to keep my students open to the possibility that there's a different way. That's the way I see my challenge. How do I both teach my students what they need to know? Because I respect the fact that they trusted us enough with their lives, their times, their money, their hearts really, to come into our classrooms to learn from us. I'm not going to take that lightly, and I teach what they came to learn. And yet, I have to find a way, I feel I must find a way, I feel there's a reason for me to be there, to teach, well, tort law is also about how much care we owe one another, right? The fact that, and to explore the possibility to invite some inquiry into these different ways we might be seeing even that body of doctrinal law. But it is not easy work. I've been drawn to the contemplative pedagogy movement, in part because I find it has created a little bit of space, a little bit of air, like it's not been already overdetermined and overfilled with this is what we have to do, as tort law teaching has become. Here was a space where we could sort of create a different course, put it in the curriculum. So I've been working with people around the country to do just that, and then do what we want in that space. And in that space, we invite people to kind of come home to themselves recognize the state of alienation that we all live in, right? And through contemplative pedagogy practices, right, sitting, meditation in law school, on cushions that I had a spy, I had a law school spy, right? We actually do. Right now we're doing body scan meditations, literally getting on the floor, but re-grounding in ourselves. Yoga, right? But from all of that, turning back in contemplative lawyer class to what does it mean to be a lawyer? How might these practices assist us in the day-to-day work of learning, communicating more effectively, working on behalf of our clients more effectively? So for me, it's about being faithful to our commitment to teach knowledge, skills, and values that are important to competent 21st century law practice, but recognizing and sort of pushing the envelope around what needs to be included in that box of knowledge, skills, and values beyond the traditional curricular stuff. So yes, work with the tradition and add more knowledge about the importance of full-bodied emotional intelligence to be effective in the world. Right? Stuff that wasn't presented in the traditional curriculum when I was in law school. More knowledge about the importance of being able to work with others through categories of real and imagined difference, right? Working across diverse settings in ways that maximize effectiveness. And how practices that are about compassionate listening and compassionate speaking with other people can help us do that more effectively. Right, so really just fleshing out the knowledge, skills, and values that I think we can legitimately now say our law students need, and then supplementing the pedagogy of that, how we teach that with contemplative methods. So again, I have this space where I can do it in my class that I've co-created called Contemplative Lawyer. But then the challenge is, how do I get it into tort law? How do I get it into insurance law and immigration law? Because to the degree we just have it in this silo over here, and I get the wonderful experience of having 20 students every semester or so who really want to do this contemplative law thing, if we're not also working on the rest of the core curriculum, we're missing some opportunities. So it's working on the knowledge, skills, and values and expanding what that means in a way that we think is legitimate based on this vision. We think it arises out of some inherent place in the world that does emanate. And once I start to kind of create spaces or support my students in co-creating spaces where they can see each other more holistically, they start to kind of be drawn to this different approach. And so it seems to be working, but it also always is up against, am I devoting enough time to the other stuff? Can I get away with this? And so I'm working on these, I'm going to wrap up soon because we have other speakers whose voices I really want us to be able to hear. I'll just say that for me, it's work that is about not only knowledge, skills, and values, but also on 3 different levels: personal, interpersonal, and systemic. Personal for me, right? Because I know I'm a work in progress, and I want my students to sort of recognize that they too are works in progress. And yet we're privileged to play these important roles in people's lives, to be in a position to help them when they're in distress. It behooves us, we almost have, I think, an ethical obligation to be trying to do the work that Maria pointed out is so important if you're going to be an advocate. We need to be doing some work, she put it last night, if we're going to be able to be anything like the kind of person who, in the midst of conflict, or even in the midst of somebody attacking us, somehow rise above it in the way that the Martin Luther King story she told indicates it might be possible. So it's personal work. It's interpersonal work because, again, we're helping students reconnect to the sense that we are in this together. And there are lots of practices, contemplative practices, not just meditation, but guidelines for communicating, listening, and speaking practices that I bring into the classroom, storytelling practices that I bring into the classroom, lots of different intentional, and many of them research-verified practices that support people in bringing that kind of an interpersonal contemplative space in, through which we can experience that sense of I and thou that we know is wanting to be born and manifest. And then there's the systemic piece, which is, something I work on so many different levels, from, writing the traditional law review article explaining why we need a contemplative approach to law and trying to push for that, to working with the AALS, this formidable organization of law schools, to get a humanizing section within the AALS, to get a mindfulness section in there. So changing those systemic institutional spaces, doing something kind of crazy to make it, create a space, then again, that space within which we can begin together to envision a different way. So thank you guys for your support. I'm going to turn it over now to my other panelist, Lenny, who I said is going to speak first, and then we're going to hear after him from Doug Amar. It's been an honor and a pleasure, and I look forward to hearing comments and questions soon. Thank you.
Can you hear me? Can you hear me? I'm trying to talk loud. It's usually not that hard. Talk.
Now we can't.
Do we need to get it on the tape?
Yeah. You need a mic or yeah.
So we can save it for posterity as well.
Oh, sure. Can you hear me now? No? A little higher as you're going?
Anybody?
Already there. So I was part of that group that was feeling challenged. I spent a lot of time sort of thinking about trying to connect what my experience was being a community lawyer to kind of the conversation that you guys have been having and want to have. And I hope you indulge me sort of to let me walk you through my thinking as I try to bring some sense to this, trying to associate kind of the language of thinking about spirituality and these types of concepts sort of to my journey as a community lawyer. As Peter said, I was the executive director of the Neighborhood Defender Service of Harlem for many, many years. Before that, I was a public defender here in New York City at the Legal Aid Society. And the Neighborhood Defender Service was an attractive opportunity because it was a vision of being able to do lawyering the way that I thought lawyering should be done. And, as I thought about it in preparation for this talk today, we talked about it as community-based, client-centered lawyering. And that was the original vision of the Neighborhood Defender Service. But as I thought about it more, it was community-based in its conception, certainly. I'm not sure that in its initial conception it, in fact, was client-centered. I think we thought it was, but I don't think it was. I think it was lawyer-centered. I think it was a vision that was intended to help us do our jobs better. It was a vision, and our jobs were to represent our clients, so I think it was a well-intentioned vision, but it was really a vision that helped us do our job better. So what do I mean by that? This notion of community-based was really an attempt to say that our courthouses in Lower Manhattan, most of our clients live in Northern Manhattan, and that impedes our access to our clients. It impedes their access to us, but it impedes our access to our clients, right? So if we were in the community neighborhood, we would have more ability to be connected to our clients. Is that community-centered? Is that lawyer-centered? It might have been a little bit lawyer-centered, right? We thought about this concept of early intervention. We wanted our clients to have representation upon request. We thought if our clients were able to call us immediately after they got arrested, then we could begin our work earlier, right? We would interview them at the precinct. We would interrupt confessions. We would begin our investigation earlier. Those things are good for our clients for sure, but in fact it was lawyer-centered as much as it was client-centered. We thought that being in the community would give us greater knowledge about the circumstances that our clients lived under it and access to their families, but it was all about us representing them better. Again, well-intentioned, but lawyer-centered. Even this notion of team representation, so we thought that we needed to give greater resources in our office to non-lawyers, greater or a larger proportion of the resources to investigators and to social workers and to paralegals, all of the supports that lawyers need to do their jobs well, was sort of another design, but it was lawyer-centered. But over time, I think by virtue of being in the community, the engagement led us down a path of what I think, in fact, was more client-centered lawyering. And as I've thought about today, I think that part of that is sort of engaging the sort of tension to some extent that Peter, I think, at least as I heard it, as it spoke to me, was sort of this tension between sort of individual and the community. So if you watch the evolution of the language about, at least in the defense context, this concept of community lawyering, you know, we started with client-centered lawyering, holistic lawyering, community-oriented lawyering, and you hear now concepts about, you know, talk about individual clients, the client community, communities from which our clients come. So even the language has evolved as we as public defenders have tried to kind of figure out what it doesn't really mean to engage with the client community in a meaningful way. So what are some of the things that happen as a result of this engagement? So I told you that we sort of wanted to do early intervention. As we envisioned it, it would be someone would get arrested. Our initial vision was they would call us. They would call us, and then we would go to the precinct. Phenomenal, right? We would show up at the precinct. Cops were surprised to see us. You know, what is it, a lawyer in Harlem for a poor community? So, I mean, there was some very exciting things about it. But, you know, clients, so we had an outreach unit. We had these little plastic cards. Thousands, tens of thousands of cards that we handed out over many years to individuals who we thought were subject to arrest. You know, what we learned over time was when we got that call was from grandma, that call was from mom, that call was from brother, father, almost anybody but the person who had been arrested for lots of legitimate reasons, right? So our wallet cards, instead of continuing to invest in those, we invested in refrigerator magnets, right? Because the refrigerator magnet meant that if someone called home to say I'm in the precinct, the person at home would look at the magnet. But that was a lesson we learned from engaging community in a real way. And it also was a service, right? Because what it understood was the person who got arrested is not some isolated individual. The person who got arrested is a member of a family unit, a community, who is, I don't want to say just as stressed out, but is deeply affected by the arrest and the interaction in a different way perhaps than the person who got arrested. But it led to a series of conversations in our office about, well, what is our engagement to the community beyond our clients, and how do we think about that? The other thing that happened with this sort of notion of early intervention is that people then started calling us before they got arrested. And they would walk into the office and they would have had some, you know, the cop came to my house, they left a card. We had no conception that as much of our work would end up being what we began to call voluntary surrenders. But it led to a sort of whole new thinking that we had to engage in. What does it mean to sort of have a person? Should you surrender them? How do you think about surrendering them? What is the impact on the family? Do you surrender them in the daytime so that they can be home with the kids? How do you take care of your kids while they are being surrendered? You begin to sort of realize what it means to represent people who are part of a community and your responsibility, not simply to that individual client, but to the person who you're representing. Is that about, I don't know if it's about spirituality, but I think it really tapped into thinking about our clients as human beings and what is our responsibility to our clients' family in addition to our responsibility to our clients. You know, I told you about the community outreach unit, and the initial purpose of the community outreach unit was to make sure that people called the office, right? The premise of the office is what people would call. And some people felt like they would never call the office. Nobody's going to call the office, so we did a lot of community outreach. But over time, we began to encounter kids who would talk to us about problems that they were having with the police. And so then we began to create a series of classes, Know Your Rights classes, and we would teach them in the local high schools. Having conversations with these young people, we developed a curriculum, and then we started really getting more intentional about how to talk with them about de-escalating police encounters. So Know Your Rights became a course that we called Conflict with Cops, and it became a longer course. I will never forget that I was at a session with some young people, and I was talking with them about conflict with cops, and essentially, the kids said, well, none of that works. None of that works. Civilian Complaint Review Board is useless. The cops don't listen to our attempt to assert our rights. And over time, for those conversations, the young people, at their insistence, really, we created a youth program within our office, named by the kids, Students Taking Action Towards Empowerment. And those young people wanted to engage in a more fundamental way the types of things that brought them into conflict with the cops, the circumstances that they were encountering. Is that a role for a community law office? And there was a debate in our office. I'm spending my time raising money for this youth program, and the lawyers want me to raise money for more lawyers and for more social workers. We're like, what's our commitment? Are we really a community-based law office? And how much do we respond to the needs that the community is bringing to us, right? Again, a product of this engagement and tapping into this sense of responsibility to the individual client, or responsibility to the client community, responsibility to the broader community. So it was really an evolution. We had a civil unit. It was intended to represent our clients on the civil matters that emanated from a criminal charge. The person gets a criminal charge, and now they're facing an eviction for possession of drugs from public housing. Is sort of the typical example that we gave. Well, what we began to realize is that very often the person who got arrested may not be the leaseholder, but might be the son. So the housing authority wants to throw the family out because something the son did. Talk to the housing authority. Well, we'll let the family stay if they exclude the 16-year-old son. So what are we going to do with that? Right? So again, we used to, I think, cavalierly say, in order to secure our funding, that we represented families, not individual clients. But we end up really, truly representing families and not individual clients. But how do you sit and, talk with your client about what he or she should think about in terms of his family's sort of stability in their home? How do you talk to your mom about that? Right? Again, it's forcing us, by virtue of engaging in community and having a true commitment to that, it's forcing us to bump up against this individual client or client as a part of something bigger than him or herself. Last thing I'll talk about in terms of just the evolution, in terms of our programming is, and I'm still sitting here trying to think of it, I don't even remember how this started, quite frankly, but at some point we had a fatherhood program. I don't remember why we started the fatherhood program, whose idea it was. I don't believe it was mine. I would take credit for it if it were. I used to tell my staff I take all credit because I take all blame. But at some point we realized that, notwithstanding this notion of absentee father and males not wanting to take care of the children, who they were responsible for, that our clients were struggling mightily with sort of how to be the fathers that they wanted to be. Some of them were people who were coming out of prison. And the program, I will never forget, at some point we began to do these evening discussions, sort of group discussions, not really counseling sessions, but group discussions among the fathers about some of the challenges and struggles that they were facing. And, it so enriched my understanding of the real life challenges that our clients were facing, and beyond sort of the particular charge that they were confronted with. And I think it enhanced the representation most of those people were not clients, but that knowledge actually enhanced our representation of other people because the circumstances and conditions that they were facing were not isolated to them. It was sort of something that other folks had faced. And so I guess what I'm really sort of describing is an unintentional, I think, necessity to grapple with what it means to be authentic about representing a community and engaging in a community. And I'm not sure I would have thought about it in the kind of engaging the heart as well as engaging the mind. I think it challenged us as lawyers in particular to rethink our role, to rethink how we spend our time. It challenged us as an office to think about where to devote our resources in ways that I think were ultimately good. And I think it's led to sort of an engagement in the defender community. I think Neighborhood Defender Service was part of a discussion. I think many other defender offices are having those discussions in varying degrees now because the field as a whole is redefining what it means to be sort of public defenders and who are we representing and what's our ultimate goal. I just want to wrap up with saying that I think there was some really beneficial effects, in terms of changing attitudes. So we opened our services upon request. People either could call us, and we had some situations where we were still assigned by the court. It was fascinating to me that the clients who called us and asked us to represent them felt more entitled to be more demanding of us. It was fascinating. They chose us. There was no exchange of money, but they picked us. I picked you. You're accountable to me in a different way. It was fascinating. There are lessons there. Because of our being based in the community and perhaps because of our team motto, I think that the non-lawyers in the office felt a sense of responsibility to the clients in ways that had not existed when I worked at Legal Aid. I always tell a story about coming back from court with a young lawyer, and we're walking into the office, and one of the paralegals says, client X called for you. Client X is on the phone. The young lawyer says, I can't take the call right now, I'm too busy. She says, no, you have to take the call. He called 3 times. I can't take the lawyer. Social worker was sitting on the other side. No, you got to take that call. The client called 3 times. I've already spoken to them. You need to speak to them. And this exchange went on, but they forced that lawyer to take the call, right? But because they had a sense of responsibility. Off-color jokes about our clients were off limits, right? It was a different culture in the office. But most importantly, I think that over time, it was more allowable and acceptable for the lawyers to show their vulnerability, to kind of express the pain that they were feeling along with their clients, to cry, to love their clients. I think that, and all of that I think was mixed up in sort of what we were developing and what we were experimenting. And I'll close with maybe it's selfish, but one of the greatest unintended consequences was in 1996, New York City decided that we were too expensive, that the model had failed, and they directed us to close by the end of the year. And after sort of getting sort of my bearings together, I had been executive director just a couple of years then, and I sort of took it personally. I didn't want this to happen on my watch. And so we tried to figure out what to do, but the community, to everyone's surprise, refused to let the city close us, right? Because we were their office, and we hadn't planned that. We just wanted to do our jobs better. I think in the process, we really understood, and still struggling with it. I don't want to make it seem like it's sort of anywhere near perfect, but I think sort of this struggle, journey, I should say, of what it really means to be a community-oriented, community-centered defender office was sort of fascinating. That's my story.
Coming over here, I'm going to show a video to start things off. I guess I need this too, right? Lenny, thanks. Rhonda, thanks. All right, next to follow. My name's Doug Amar. I'm the executive director of the Georgia Justice Project in Atlanta. And, I'll make a little multimedia. So just to orient you to our work, I thought I would show actually our only video, all the video we use. It's a fundraising video, so it asks for money that you can leave the checks outside. So I apologize for that in advance because it's not like we have 18 of you to show you. All right, so Ryan, are we good?
Right.
All right, do we need to turn any lights at all?
Yeah, you would like to be on.
I mean, just know that you know this room better than me. So. Okay, all right. And stage it. There we go.
I would imagine that once one is caught up in, some refer to as the criminal justice system, which probably is more accurately described as the criminal conviction system in the state of Georgia. And for most of those people, it's almost inescapable for them.
So you should care, first of all, that there's a great level of injustice happening to the people who have the least amount of ability to help themselves. And then, if that system keeps rolling, then it causes everybody else to pay for it.
So 2.6 million Georgians have a criminal record. It's 1 in 4. It's a quarter of our population have something on their background. We must deal with those people and their ability to become tax-paying citizens and contributors.
The Georgia Justice Project provides 3 different things in the community. The first thing we provide is a holistic criminal defense approach to folks facing a criminal charge. Folks come to us as clients because they have a case pending. They need a lawyer. They're looking for legal help. And that's what we offer people. We offer that to people at no charge.
After that, it's about engaging them to the point that once you recognize what it is that is a shortcoming in their life, trying to provide the necessary resources to deal with that. And education, employment, sometimes it's just counseling about life's difficulties, because it's important that people have a story to tell. And I have a listening ear. Part of what I do is to listen to people.
The second thing we provide is direct representation, helping folks directly as the lawyer overcome the impact of a criminal record.
I work with people every day. They come in my office and they have a record and they're trying really hard to move on with their lives. Perhaps something happened 10, 20, even 30 years ago, and it's holding them back. They don't understand. I did everything I was supposed to do, and still I can't get a job and I can't move on with my life. At what point does this stop?
So what we do is we assist people by doing expungements, record corrections, advocating on their behalf to employers, housing authorities, anybody who will listen to us. The best way to get people out of the system and on with their life is getting them stable employment. That the answer to the problem, if you want to keep people from going through the cycle, is to give them a stable job, gainful employment. Let them contribute to our society instead of keeping them as an outcast in it.
The third thing we do is to help change the laws in Georgia and educate folks about these issues, taking a policy approach to changing the culture, changing the laws in Georgia to make it easier for people who have a criminal record.
We all can agree that we want people to be productive, and so if there's an opportunity for people to redeem themselves, to heal, to recover, we all want that to happen.
And no one else in Georgia is doing this work that Georgia Justice Project does. And I'm particularly pleased that the reach is getting beyond Atlanta, and its presence at the legislature has made a world of difference.
It's not something that is unique to any political party. It's not unique to any gender or race or neighborhood. And it is something where we have been able to see groups come together to work towards these common goals to solve some of these issues that we're talking about.
Not enough members of the General Assembly have a real personal connection with the criminal justice system. And the Georgia Justice Project brings real stories and real people. I can count on them for the kind of policy substance that we need badly. I'm grateful for the gifts that they bring.
We are supported solely by individual, corporate, foundation, communities of faith, donated dollars. So what you can do is to help us provide that support for people who don't get it through their family and in their community.
Regardless of how we think philosophically about criminal justice system, and issues impacting the criminal justice system. It's only a matter of time before somebody we know is impacted by it.
It's important that you understand that whatever impacts an individual's life impacts the community, which indirectly impacts society at large.
It is such a heartwarming feeling to know that even strangers care about you and want to see you do good in life.
I did not have a clue how I was going to be employable, be a productive member of society again. And whatever Brenda Smeaton said she was going to do, she did. And I really appreciate that because now I feel employable again.
We can't really be rich if others are poor. We can't really be healthy if others are sick. And we can never really be free if others are incarcerated. That's what's important to me about the Georgia Justice Project. That's why I think we do what we do.
Okay, unadulterated I'll mix it up a little bit here. Well, unadulterated self-promotion. So let me, here's what I'm going to just talk about. The focus, Peter's asked me to talk about really our focus of the first bucket, and that is what we do in court for the criminal defendants that we represent. But so I'm not really going to talk about our collateral consequence work or our policy work, or even our sort of coalition work, which actually really knows more about this probably. Oh, is the mic not on? It's not. Oh, is it? I thought it was on. It's on. I guess you gotta move it up. Move it. On the east side. So I'm not going to really get into our policy work either, but I'm certainly glad to talk about it with other folks later. A couple key things about our organization I'll let you know. First of all, this orientation to King obviously is powerful for me, but those who've been to our office, and a few of you have, we are directly behind the grave of Dr. King. We're on the same block as the historic Ebenezer Church. We're half a block away from where Dr. King was born. And I got to tell you, we've been on that block for 26 years, and we've been on the spot where we are for about 13. And it's, I always tell people it's sacred space. It's powerful space. And every now and then, our board would talk about wanting to move the office because the neighborhood around us is getting a little hip and hot, and bars and restaurants and art galleries when it used to be full of our clients. I said, no, we can never move. I mean, we cannot get this space anywhere else. I mean, we're in a historically African-American neighborhood, one of the first middle-class African-American neighborhoods in Atlanta in the 1870s, 1880s, a block away from Sweet Auburn, for those of you who know what that means. So it's a powerful place to be, and King is obviously a big part of our, I think, a part of who we are, I mean, obviously. A couple of the key things, I'm not the founder. I've been at the organization for almost 25 years, a long time. I'm only 27. Perry, I got to compete a little bit with the joke. But our founder was a corporate lawyer who was a King and Spalding lawyer who really through his faith as a Christian tried to reach out and integrate his practice as a lawyer to serving the poor folks. And he started this work, and I can talk about that if you'd like to. We're a small nonprofit. As I mentioned, we don't take government funds. We don't take court appointments either. We raise all of our private dollars, about $1.3, $1.4 million in budget, about 17 staff, not all full-time. And we don't charge our clients for anything that we do. So again, I thought I would just really tell you a quick story. And those of you who know me, I love to know stories, and I don't think I've told this one. I think Marjorie might be the only one who knows this because she might have read it. But it was a few years ago that a young woman who was fixing, as they say in the South, fixing to graduate from high school. She had never been in trouble before, 2 weeks away from graduation, and some of her friends, they jump in a car with us, we're going to ride around, and well, unbeknownst to her at the time, they were planning to rob somebody. Somebody had a gun, they pull out, often happens, 3 or 4 guys pull out the car, they robbed this guy, they planned to, of a computer, a little bit of money. They didn't even get home before the cops arrested all of them, and she was arrested and in jail. And she was looking at 10 years in prison. Armed robbery charge in Georgia. The mandatory minimum movement has created that. If she were to plead guilty to what she was pretty obviously guilty of, meaning there wasn't a real factual defense in this case, she was looking at 10 years door to door, no parole. So her family contacted us and asked us to look into it. And as we do, we interviewed her. She was in jail. We interviewed her with a lawyer and a social worker. And after a few interviews in our process, we agreed to take it. But we said to her, she said, well, how much is it going to cost? And we said, we don't charge anything. But we do expect a commitment. And the commitment's going to be with the social worker, with what's going on with you. Whatever your need is, whatever's underlying your issues, we're going to have a plan to help you address it. And we expect you to stay with it. That's her commitment, and that's what she has to pay. And she agreed to do it. Now, as again, we're faced with a pretty tough situation. In an early hearing in the case, the judge, who's, I see this judge around a lot now, he's not on the bench anymore, he's a tough judge, and he looked at me, and he can be really aggressive, this guy. And he just looked down, we were in court, and he just sort of slammed his hand and said, is she ready to take a plea today? Because I'm going to send her to prison for 10 years today. And I'm like, I mean, as any good trial lawyer, I'm like, whoa. I'm just like, I was totally, I said, Judge, can I approach? I mean, what's going on? You know, and I, stammered and stalled as every lawyer's trained to do. And I went to the bench, and he was, this guy, he's an aggressive guy. He's from Cleveland, always wears, he always used to wear hockey jerseys under his, African-American, hockey jerseys under his robes. I mean, I could figure that. And he looked at me, and he knew who we were. He actually lived in the neighborhood where our office is. And a lot of judges now know us, of course, but he looked, he says, hey, the first question is, he turns up, why are you helping her? Because he knew that there was, he knows, I said, he said, why are you wasting your time? And the judge knew that we weren't there because she paid us, because we don't charge. The judge knew we weren't there because he told us to be there, because we don't take court appointments. And actually, one of the hard way over the years, one of our lessons is, when a judge calls, we say, Judge, give our name to the client, because we're going to have them contact us, because we're not going to come through you to the client. We're not going to come through the court system to them. We're going to come through the community to you. That's really when he comes from. One of our lessons. And, so I looked at him, gathering my composure, and I said, Judge, I'm here because we believe in her. Her name is Beth. And I pointed to the social worker who was sitting in the audience, in the stands, and I said, we are here because we believe in her potential. Now, we got her out of jail. We had worked on the case, and over the course of the next year, we filed motions, investigated, and were able to get the case reduced, which is the big deal for a criminal defense lawyer, from a mandatory minimum to a non-mandatory charge, which in this case is robbery, and got our first offender. And she stayed out of jail. And actually, 95% of our clients every year do not go to jail as a result of having a case, even serious felonies like armed robberies, ag assaults, and murders. So we're pretty successful in keeping our people both winning the case. We have an 82% dismissal and acquittal rate, plus a 5% sort of incarceration rate. And that we've been tracking this for years, and it's been pretty much the same. So seeing Beth in that case and seeing the judge's reaction, of course, we have to overcome his own leanings, but that really represents a lot of what we do at the organization. I tell Beth's story because I see her quite regularly. I saw her not long ago in the office, and she was coming in the office to meet with a counselor because she had a job and she wants to get a better job. So she was coming to work on a resume. One of our social workers really focuses on employment, and we keep our door open for clients sort of ad infinitum, really. And there's that point, sort of how we approach our relationships with our folks. I wanted to pull up, there's something on our website to show you just one of the things we do to do this. I'm just going to pull this up only because it's a great little visual. You can't really see it too well there. This is a back to school event we do every year, and we've done it for a while. But we have it, we invite anybody we've ever served as a client. And so every year it's about 300 to 400 folks show up and their families. We have volunteers, a lot of big law firms and other folks help us. We have Coca-Cola, company gives us all product. There's a picture in here of Chick-fil-A giving us some food. But the point is that we reach out to our folks on a couple times a year to invite them to have a meal together, to invite them to have fellowship together. We invite them at Christmas time. That's one of our other big events. The picture's on our website about that somewhere. But what we've seen over the years is at first we really thought we were going to be serving like our clients, and we are. But many times it's our clients' kids and now their grandkids, and sort of this ongoing, sort of deeper relationship that we've established with our people. That is really about, I think, the core of what we're trying to do. The back to school event, as you see, has a bunch of, we give out backpacks. One of the cool things we're starting to do, and this is what this is about, this picture is about voter registration. We have a client advisory board that meets, and we've been gathering information and momentum on affecting the disenfranchisement about folks who have a criminal record. Georgia is actually pretty good on this front, but there's a lot of people who deny the right to vote because of their criminal record. And So we have, so we're working on that, and it's great to see our clients sort of, as an advisory group, move that issue forward. I just want to pull up one picture. I'm sorry. I'll get it in a second. Not that one. I'm sorry. I just thought I'd give you some visuals. All this talking, you know, you got to have a little bit of pictures. Got to have there's some of our interns from the summer. There it is. So we have this phrase we're calling it, in Georgia, and it's in some states, and I won't get into the law, it varies, of course, state to state, but you probably know, and Eric Holder did a great talk on this recently, the further you get to the deep south, the closer you get to getting rid of losing your vote when you've got a conviction. There's only a couple states in the country where you keep your vote no matter where if you're convicted or not. Rhode Island has passed a great law. I think Maine is pretty good. I think some place out west in Wyoming, I forgot which. But the point is, Georgia's got a good law. And that's if you're off paper, if your case is over, for those of you not criminally attuned, off paper means when your case is resolved. You're not on probation, parole, no fines are still pending. When your case is over in Georgia, you can actually vote again. But what happens is a lot of people show up to vote, and there's a roll there that shows a conviction, there's a list of people been convicted for 20 years. And they say, hey, go get this, you can't vote because you've got this conviction. Even though that's not the law, the problem is how do you prove you're off paper, which is a whole other problem. And we have some legislation pending about that as well. So I just want to give you some sense of some of the scope of our work, and I want to just really spend a couple minutes talking about what I think are some key qualities, key elements to how we approach our work. For us, and this came out a little bit yesterday, I was going to bring it up, Rob. I thought it was a good opportunity. Somebody said something yesterday. For us, choice is a huge, huge deal. As I mentioned, we require our clients to ask us for help. When even parents call us, we say, that's great. Bring your son in, bring your daughter in, or we're going to send them an application in jail. We'll go talk to them in jail, but they have to ask us for help. Because we look at our work as forming a relationship with people. We look at that they have to want that relationship. I know they don't know what they're getting into when they first say, we're a free lawyer. We're not the public defender. And that alone puts us in a very small minority of opportunity. I know that. But the point is that when we engage with somebody, obviously it's not going to just be for the case. It's not just going to be for prison. If folks go to prison, we visit our folks in prison. When folks get out of prison, we help them get back on their feet. And as I mentioned, very few of our folks go to prison. But the point is that folks have to want that relationship. And we approach this like a bargain. So many times when clients don't fulfill what they're supposed to do, or we ask them to do what they've agreed to do, whether it's stay in treatment or finish their high school, whatever's going on with them, that we'll sit down with them and say, do you want our legal help or not? And they say, what do you mean? Because we have a deal. And the deal was you would do what you said you were going to do. And we're not asking them to do something, we're not asking them to pick up trash on the side of the road, we're asking them to commit to their own future. And it's stuff that they've identified, not stuff that we've identified, stuff that they've identified as being important to them. And we've fired clients. We've fired clients who said, because some clients come to us and just think we're going to be this a free lawyer, and I'm done, I'm just going to get off, and that's it. We're good lawyers, but we use it in the context of a much larger goal for our clients in the community. So in many ways, this way of approaching this relationship, this way of approaching, not just doing the case, but staying with folks in prison and their families. More and more our work in the last 10 years has gotten very deep with working with our clients' families and then helping folks to get out. And that sort of got us into this whole collateral consequence issue a number of years ago. But in many ways, this is taking, the way I like to think about this, that does fit into some of the conversation, is that this is really taking a one-dimensional encounter, a transactional encounter, both with the lawyer and the client and the court and the client, and making it three-dimensional. And that's a lot of what I see us doing every day, is that we're actually judges in particular, and prosecutors, if you can, we just want their assent. We don't want to convert them, and we love to, but I don't expect that of prosecutors. But I do want the judges to be converted. I want the people to sort of see the people, the clients, going through the system in a different way. Because that's how we're encountering a different way. We're getting involved in their lives, we're committed to them, and we expect the court system, we hope that the court system will likewise sort of see that person in a different way. So what becomes, what starts off, and as often as those of you who spend time in court, this one-dimensional sort of moving through calendars and cases over and over again, is that we want it to be three-dimensional. We want the court to see the person in a different way. And I mentioned this too, a lot of times you ask if you could say, well, Doug, this gets to our 82% dismissal rate last fiscal year, or 82% acquittal rate. You'd say, well, gosh, are 82% of our clients not guilty? Probably not. Why? Well, how do we get that kind of result? We get that kind of result because judges and prosecutors are willing, they're buying into this vision of a different way of approaching the client. They're saying, look, I know what's going to happen when I put on probation, and I give them fines, or they go to prison. I know what's going to happen because I see it every day. Those who are judges know this. They know this. You all know. But so judges, what I find so fascinating, and it really fits in with this whole point, is that people in the system are dying for a different way of doing things. And so when we show up, I mean, they were like, please, what do you want? We used to call it the GJP dismissal, and we create our own diversion for it, because there's so many people who are so tired of the same old thing, because it's not working. It is just not working. And so that's one of the ways I think why we're successful, because we're just doing things, and it's so in keeping with Peter's philosophy and what he's writing about, what he's talking about, is that there's such a thirst for seeing folks more wholly, and there's such a thirst at the systems, not just the people, not just us right here, but the systems, open up to that freshness. And that's where I see great opportunity. That's where I've been doing this for a long time, and that's probably why. So let me check the time. I'm sure I'm about done. Yes, I'm way over now. Let me close this with two quick things, and I want to say, first, I appreciate Peter mentioning something about me personally. I almost feel I appreciate Ron talking so much about your own journey. I would love to talk about that in the context of both race and class and calling and faith and a sense of service and suffering. These are huge parts of what bring me to this work growing up. And I grew up, and I should say too, my grandmother used to call me, she asked, what race are you? Because my dad was Lebanese, my mom was Hungarian German. And, she would look at me and she would just call all her grandkids half-breeds. It was really great. She was a great person. But I mean, so this sense of otherness, is a deep in my own sort of history. But also, fortunately, unlike Virginia, where Ron is from, West Virginia actually integrated the schools in '56, like the damn Supreme Court said to do. Took other deeper southern states longer to figure that out. You all know that. So I grew up in very integrated schools, and I went to college, and of course, this public school integrated. And the other part of this is important to me is that this was just part of my culture. Half of my high school class was African American. I grew up in the inner city and grew up very poor in West Virginia. But my wife is African American, and I say this only because in the context of the opportunities that the civil rights movement created. I think about that all. I mean, being right by King, I think about it all the time. I would not be where I am or who I am. My kids would not be who they are if but for the civil rights movement. I mean, I'm not just connected to it like, hey, I'm right here and doing cool work. I feel like my life, my family is different because of this. Well, we talk about today, but I'll talk about that. So anyway, I can talk more about that. But one last thing I want to share, and it is a client story. So just the day before I left the office, Tuesday or Wednesday, a guy who was from New York. We represent a lot of New Yorkers. A lot of people leave the city and come south. I feel like it's the inverse of that Stevie Wonder song, right? Show up in the city and go to prison. It's the opposite, man. People leave New York, come to the south, they get arrested and go to prison. That's what it is. So one guy we represent on a murder case, he's from 18, 19 years old, drug problem, leaves New York and comes to Atlanta, catches a really tough case. We're able to keep him from being a murder conviction. He gets a manslaughter conviction. He goes to prison. We visit. I've been visiting him for 20 years. He gets out. He struggles for a little bit. He's in the office on Tuesday or Wednesday, and we hadn't seen him for a little bit. He's been out for 2 years, and he's in because he's about to be evicted from his rooming house, and he lost his part-time job, and he's in the office, and he's meeting with the same social worker that's on the video. And I step in the office, and his name is Randy. I said, "Man, what's going on?" And he starts talking about being alone, and he starts talking about how he needs to rent, he might be evicted, but he's alone, and he doesn't know what to do. And he's crying, and I grab him. I've known this guy for really like 24 years. And I grab him and I hold him. I say, "Randy, you're not alone. That's why we're here. We'll cut a check to you. You'll have a place to stay. That's not the issue. Money's not the issue. Money is a mechanism to get to some other outcome. And in this way, the law is a mechanism to get to some other outcome. It's a mechanism to get a deeper relationship with people to avoid the consequences that nobody wants. Nobody wants to go to jail. Nobody wants to be arrested. All those things. So for me, I think about that every day. I think about our work as being a great opportunity. I'm very honored to do the work that we do. That's probably why I've been doing it so long. It's not because of the pay, believe me. And I'm really honored to be here. Peter, thank you. I'll stop. We have questions, right?
One question that occurs to me, to Lenny and Doug both. Doug, you said you have this great relationship with the courts. They're so delighted that you show up. You offer the GJP diversion track. Yet I suspect that your percentage of people you represent as opposed to public defenders is what, 5%, 2%? Lenny was probably the same for your Harlem office too, very small. Do you feel like what you're doing and the success and the richness of it is contagious? Do the public defenders start to change their tactics and behavior because of what you're doing?
Yeah, it was a small percentage. It's getting larger since I've been gone. But I think that maybe related to the point that folks hungering to do something different. I think that there is some sense that thinking about role differently, thinking about scope of representation differently, I think is something that whether it's contagious. And when we started in 1990. This idea of community-oriented defending or holistic representation wasn't a common concept. I think it's much more common, and there are many, many more offices that are trying to implement it in different ways. So to that extent, I think it's been effective.
Yeah, we were started in '86, and I, back then most public defender offices in the country didn't even have social workers, and so now, when I'm around the state, around the country, more and more, I think there's more and more of a movement towards however folks want to define holistic, and Ed even gave one definition earlier. I mean, there's always talking about it. But the point is, I think there's a movement to recognize, to offer more services and deeper commitment, whatever that might look like. We're lawyers next time, Peter.
I have questions for both of you, each of you, but Rhonda, the contemplative awareness, is that in torts as well as in your contemplative law class, that you pause at the beginning of class for a moment of silence, or bring in cushions into torts, or? That's not my whole question, but that's my first
so I
question.
haven't brought the cushions in, but definitely opening the class with a conscious settling in practice. They know who I am, they know that I do this mindfulness work, so I don't have to preach much about it. But I normalize this idea of we enter in consciously, we gather, we pause and settle and kind of consciously, basically it's a kind of a meditation practice to begin the torts class. And then I add dialogue opportunities into the class and have given them some instructions about how to listen to each other more richly, to look at not just what's said, but body language and all of that. And just allowing them to kind of loop back and listen to each other and share together helps underscore the relational dimension of law and life in the torts class. So I'm still working with how to bring it in the torts class, short of bringing the cushions in, which I haven't figured out how to get away with.
So one follow-up to that is, then the question is, can you bring it into the doctrinal teaching? And one thing I was wondering is if you can slow down the discussion of the facts so that people can actually experience these often traumatic and tragic situations. I think we did a reading once in PISLAP at Fordham session, at the meeting we had at Fordham, where we did a slow reading of Yania versus Begin, the duty to rescue rule, where one guy sort of banters, as they say, another guy to jumping into a strip mining crevasse and drowns, and no one helps him. And there was something about the slowing down of the narrative and of allowing people to hear it that altered their way, in our way of thinking about it, and might alter the students' way of then jumping into the analysis and saying, oh, you can't have a duty to rescue, then everybody would be subject to liability, where they're out of touch with what's taking place.
Yes, I mean, I do try and do things like that. I didn't finish the last part of the story from my colleague here from our small group. She said she'd gone to this place and realized she has a sense from law school, nobody's obligated to help me, and yet all of these people came to help. Right, so just, again, the way in which the training is not what we experience necessarily in our everyday lives. And I have had the experience of my students saying, yes, I learned, no duty to rescue, no duty to help another person, and somebody was falling in front of me on my way to class yesterday, and I threw all that out the window and reached out to help them, because that's, you know, that's what we do. And so there are ways we unpack this so that my students can reconnect what it is that they believe is really most germane and true. I'll also say that it's hard because of the time pressure, and I have to figure out what I can cut to make more time to be able to do that kind of work. One way I try to kind of pack it all into one particular lecture is the famous Paul's Graph case. I mentioned that. You know, we all teach Paul's Graph, Mrs. Paul's Graph, famously on Long Island, getting on the Long Island Railroad and the whole explosion, all of that. I actually traditionally, basically dress like Mrs. Paul's Graph for the purpose of saying, here's a real person behind all of these cases, actually. But for today, we're actually going to kind of meet your first client. It's going to be your first source client. It's going to be Mrs. Paul's Graph. And I dress in this way that shows her class situation and invite them really to reflect on what it might have been like from her perspective. We never talk about this real woman who suffered. And so I do try to find ways to kind of create space. And students say, it was the first time I really realized each of our cases has a real, it's sad that it took them that long, but it was that kind of exercise can get them really thinking outside the box of there are real people behind these cases, and I try to do that. But and I will continue to try, because that's where I feel like we can do the most work in the doctrinal courses.
Can I ask my other question then to you guys, which is, so your offices then become another place for people to go. In Doug's example in the last one, a guy says he's alone and he's crying, and you said, no, we're here. You're part of us. Were you, Lenny, were you able to do that in Neighborhood Defenders? And does that then becomes a kind of, you said that people rose up to protect your office when it was going to be not defunded. It becomes another space besides the routines of the existing world where justice and presence and care can be felt. Then people can go, maybe I'm like, you know, go to the flame, go to the hope that offers.
Yeah,
I'm asking you about that.
I think that's true. I mean, it happens not without consequences, right? I mean, it sort of calls into question sometimes what are appropriate boundaries, just in terms of realistically what can you do and what you cannot do. You know, there's still a limited resources, and I think that it sort of creates lots of discussions. But we also became a place. You know, we were fortunate enough to have nice space, and so it also became a place where other organizations, entities could use the space, and so there was a sense of community, independent of accessing our services, but also a meeting place, a place where other folks could do their own business.
Yes, Gretchen.
I thought you were going to jump in there, Dennis. Thank you so much for all three of your presentations. They were just wonderful. I directed an organization in DC that engaged in similar work, but in a much smaller model. We probably only served less than 200 people and had a team much smaller than about 10 each year, including a team of 10 that would serve about 200 a year, and it would be a combination of social workers, lawyers, community organizers, survivors of the criminal justice system, and front end as well as back end representation of rights of those incarcerated. And I found that it kept hitting up on a regular tension that I really would love to hear you two, particularly Lenny and Doug, speak to, which was what I noticed as a tension of general community acceptance of a right to representation, but an adoption of almost that housing and health care were privileges, community integration, employment were almost seen as privileges that were to be earned, whereas legal representation, particularly in criminal defense, within the legal field, was adopted as a right. And so I feel like we would see it often play out with judges would love for us to be there, but oftentimes it would be in trying to cherry pick with who would get this housing spot, if that was going to be identified. And I've seen it also, not necessarily within the organization, my team, but oftentimes in a lot of other organizations or even through funders, a prioritization of funding that's going to be going to legal representation by the attorneys, the challenges of even getting funding for organizers, for social workers, and for those in the legal field to take that type of work as seriously as in-court representation. And then I would also see it played out even with the individuals who were represented, even though I love your model, Doug, where we had a similar model that the representation contract would be built on the goals and what they were going to bring to it. But as was stated so well earlier today with Peter, a different form of engagement is difficult for people. Even someone may be asking for supports in the trauma they've been experiencing cycling through these systems their entire life. That does not mean that they're not going to react in the same way that they have been taught or been limited in being able to experience the previous representations. And so I just would love to hear how you all have addressed, how you were able to address that tension, and particularly because you stated, Lenny, that there was kind of almost a youth organizing aspect with your group. How was that integrated within the legal services, and were they taken as seriously by those who were working as lawyers, and how were you bringing that to funders as something that had to be integrated within the model? And Doug, I'd love to hear how you've been doing the same with all of your programs.
So we'll be camped out here for about 3 hours while we answer that question. That's great. It's great. That's just a lot of stuff. Well, let me, two things I want to say first. One is, and I think Peter and I agree on this, and I wanted to say this on our legal and small group, is that I think it's really time for these rights that really only came about in our lifetime, right? I mean, the rights of, even a lawyer, the Gideon right, for instance. The rights or the opportunities from, the war on poverty in the Great Society, that it's really time for those programs and those to evolve, and the right to get, because the rights-based thing is minimal. I mean, Gideon is minimal. These things, if we think I'm not saying they shouldn't be there, but I'm saying we've got to let them grow. And I'll tell you, criminal defense lawyers and people involved in the work we're involved, they're the worst, because they think they're just holding on to that daggone Constitution and that case from, and saying, this is it. I'm like, no, it's not. It's a beginning. Let it be a beginning and not an end. And that's the problem often with a rights-based approach, is that you think of it that way. In our office, we talk, I really think what we're really doing, we talk about this a lot, is we're creating community. Is that we are both creating community for our clients in the beginning, but we're also reinforcing community for them when they get out, and even the folks who are trying to get a job by removing the barriers so they can rejoin community. And if you find, our staff is really clear, and it's taken me a while to get everybody, but really, we're clear that the law is just a mechanism. It's a tool towards a larger end. And that's hard for lawyers to buy into, because that we think of it, just like we hold on to that Gideon right. That's one that just jumps out at me. I'll stop there and let Lenny.
I want to be mindful of time. I just had a couple of quick reactions. One is, I found that, so my example of choice versus not choice, I found that clients have come to expect not much sometimes from the representation. They sort of expect second-class representation. And so I had not experienced so much not thinking that they had rights to other things, but with respect to the representation, I think what they think they're entitled to has come to value in their own minds. Is one point I had. Secondly, I think that there is an elitism. We used to joke when I worked in legal aid, sort of this whole worthy poor, unworthy poor kind of dichotomy, and I think that exists both within the officers to provide the services, and it certainly exists in the court system, which may result in some of the things that you described. The thing that was most significant to me about that is the absolute sort of resentment and hostility that we experience in court to the fact that our clients had the right to choose us. You know, we had the validity that being retained, and that's what we called ourselves, did not require the transfer of money, because the administrative judge did not like the fact we called ourselves retained counsel. And that is about an attitude about poor people, right? And the last thing that I will say is that the youth programs that I talked about no longer exist, because there was, at the end of the day, competition for resources to go to the legal practice, and I understand why that happened, but the lawyers were king in an office that had these other programs, and so I think that the lawyers still had work to do to really make some choices about what were appropriate resources for the office.
Many thanks.